I'm going to cover spectator injuries. So a lot of things happening during the game, probably before the game, during the game, and after the game. So a couple of years ago, San Francisco Giant fan stepped LA Dodgers fan outside their AT&T Park. And a year before that accident happened, LA Dodgers fan hurt the San Francisco Giants fans at the Dodgers Stadium. So rivalry, kind of a rivalry, as rivalry increases and more potential danger stayed and remain at the atmosphere of the sporting event. So I want you to think about how could you prevent your fans, mostly business invitee, from potential danger, because you have a duty of reasonable care to the fans. And spectator at facility typically invitee, once again, mostly business invitee, and a small portion of fans must be licensee because they have a complimentary ticket, or they were invited to the game because of their birthday, or they some special invitation ticket or discounted coupon. So owner has a duty of reasonable care to the fans. And take a look at some of the common issues at the stadium. Number one, crowd control. Crowd control, what does that mean? Crowd control. So these are four major problem at the spectator sports. Crowd control. What can you think of? Can you think of any group in the European soccer, especially UK? Hooliganism, right? We call it hooliganism. And then those are one of the dangerous groups of people, especially at the soccer game. So the blacklist will be sent to the FIFA World Cup host countries. 2002 Korean World Cup, Korean Japan World Cup soccer. Then we were provided the list of blacklist from hooligans. So they will not. They were able to come to Korea or Japan during that period of time. So what else? Crowd control. Can you think of any close example in Korea? Crowd control. Okay, so by the result of the game, the outcomes of the game, some fans, not many, but small portion of the fans get angry and get violent all of a sudden. So they will be wisely protected. Okay, or they should be protected or managed in an effective way to prevent further dangers. Okay. Number two, injuries related to alcohol consumption. So what do you think about drinking at the venue? Do you support or not? Because when I was teaching sports marketing class at one of the other Korean university in 2006, and then I just mentioned that first time I taught at the Korean university was 2004, and then alcoholic beverages were not allowed at this sports game. And then some professors who studied in the United States proposes that alcoholic consumption, alcoholic beverages should be allowed in Korean sports, especially professional level. So they actually utilized some American policy to the Korean setting. So now we actually enjoy alcoholic beverages at the many sports game. But pros and cons. Good for the money, bad for potential liability. So one of university in the United States allowed alcoholic beverages at the football game. Once again, college football game. For the first time, when some universities still selling their alcoholic beverages, making tons of money, but this university actually never allowed before, and then they started thinking of, oh, okay, we need to generate more money from selling beers. Okay, and then the revenue of alcoholic beverages, selling beer, was more than $100,000 a day, more than 1 revenue for one day game on Saturday. However, in the same time, you have to assume that there's a potential liability will always remain and always stay and stand by around your standing. So gotta be careful how much you can prevent, and then what kind of beverages can you sell. Just beer? What kind of beers? And when to stop selling during the game. Halftime? Or what about baseball? All the alcoholic beverages will be stopped, or the consumption will be stopped before 7th inning. No more alcoholic beverages after 7th inning. What about hockey game? Okay. Halftime, second quarter. So depending on the nature of the sport or format of a sports event, then they have a specific rules when to stop selling alcoholic beverages. But I'm going to share some of the interesting story happened at Arlington Park by Texas Rangers. Okay, number 3, injuries by players. Injuries by players. I showed you the video, right? 2004 NBA brawl. Okay, short video. So players, it happens, and then I showed another video. First day of a class, I think second day of a class. One of the Korean basketball players were hit by Chinese players during the friendly game, sponsored by Samsung cell phone. Number 4, injuries by projectors. Injuries by projectors, like a foul ball. And then the article I gave you, they talked about foul ball. How many fans were hit by foul balls? Okay, a lot of fans. More fans hit by foul balls than the hitters. 3 fans out of every 2 games were hit by foul balls or broken particles, broken baseball bat particles, so projectors. Or some pitchers actually try to hit the fan. Some pitchers threw baseball to the fan directly. They were trained professionally. So if they wanted to hit the baseball to the certain fan, certain location at the stadium, then what do you expect? They can hit it, that person. So it happens a lot. Okay, so crowd control. So I just want to share a couple of more interesting cases happen. So fact 1, in one well-publicized event, Frank Francisco is a player from Texas Rangers, then threw a metal folding chair into the stand after being heckled. A fan suffered facial injuries, and she and her husband have filed suit against Francisco. That's interesting. That's another notion in terms of vicarious liability. Okay. So Rangers and the security firm involved. According to vicarious liability right here, the battery, so this is assault and battery, but there's no assault, but just battery. He had a strong intention to hit, and then actually he threw the bat at the metal chair, and then there's no lack of consent. So Rangers would not have vicarious liability for his actions. So think about, do you believe Texas Rangers was negligent because of Francisco's behavior? I want you to think about Mekichan case, Mekichan versus St. Louis Hockey Club. So Mekichan filed a claim against the other player who had actually hit the Mekichan. Also, right? Also, the owner of St. Louis Hockey Club, because he believed that St. Louis Hockey Club has a duty to train the player what? Sportsmanship. Same thing. Do you believe Texas Rangers have a duty of care to train and teach sportsmanship and all the ethics to professional player? Once again, from the 2004 NBA brawl, do you think all the head coaches and team owners have a duty because they committed some violence? So if you look at this, the rationale is right here. Rangers ratify Francisco's conduct by failing to discipline him in any way. If there's allegations ratification are accurate, the Rangers organization could have vicarious liability. So which means vicarious liability will not be applied unless that's the mere negligence. If you're trying to hit someone during the game or after the game or nothing to do with the game, owners, including coaches and managers, are not liable because you are adult. I cannot control your temper. You have a temper. You're upset. You committed some criminal law, assault and battery, intentional tort. Not my fault. So the notion of vicarious liability only valid at the level of mere negligence. If I'm negligent, university president will be negligent in terms of vicarious liability. But if I commit criminal law or causes intentional tort, if I hit you in your face, then university president or department chair or dean of School of Arts and Physical Education not liable because they don't have a duty to discipline me because I'm adult. So unless it's mere negligent, there's no vicarious liability involved. So I'm going to tell you in terms of vicarious liability today. So fact number 2. So another example of player-fan violence occurred in the NBA, the battle of November 19th, 2004 at the Indiana Pacers versus Detroit Pistons game held at the Palace in Auburn here. The video showing this violence, the player attacks open fans were repeatedly shown across the nations. So these are one of the examples. Also, there's 4 more notorious cases. The court in Telega versus Security Bureau imposed liability on a professional sports complex owner where the owner failed to protect a spectator from other spectators longing for a souvenir football that was kicked into the stand. And then this is interesting. Number 2, more college basketball fans are rushing the court after dramatic wins than ever before. Coach K is the current coach of Duke University, and also he's the head coach of Team USA, the Olympic Games. He's actually leading the Dream Team. So Coach Mike Krzyzewski, how do you pronounce? Right here. Krzyzewski. Okay, thank you. So I think I am correct. So send his players to the locker room with 1.7 seconds left on the clock after Florida State, fans came pouring onto the court prematurely in what turned out to be 79-74 FSU win. The win ended Duke's hope of going undefeated in the ACC. So this is one of, not rivalry game. This is one of the upset. Nobody expected FSU, Florida State, would win over Duke University. Duke University didn't lose any game that season. And then this is the only game they lost to FSU unexpectedly. So, for the safety reason, he took all the players to the locker room with 1.7 seconds left. So what do you think? What kind of problem can you see? Can you see some difference between American sports culture and Korean sports culture? This is one of the crowd control issue. At this football game, collegiate football game, NFL, NCAA, they have several different plans. Plan A, Plan B, all the way to Plan Z, which means if A team wins, home team wins, B, away team wins, close game, overtime, depending on the scenario, they have a different plan in terms of security and safety. For example, if there's upset, home team wins over one of the strongest team, who is away team, then what would you do? They will pull down, because what do you expect? What do you foresee? They're going to climb the goalpost of the football game. There's a couple of fans actually fell down from pole and then died before. So they knew that's the dangerous. So they trying to let the pole down. And then what do you think about thousands of fans rushing into the stadium playing field? Do you think you need to protect them running toward the playing field, or you have to let them into the field? Same thing in the number 2. Baseball game, 1.7 seconds. And fans so upset. Okay? They were so excited about the winning over Duke University, and then they couldn't wait until 1.7 pass. So they actually running through the playing field. No matter who stops, they don't listen to. So what would you do? If you're a security manager, would you let them rush into the playing field, or you going to stop? You're going to protect them running to the stadium, the playing field? What would you do? This should be kind of a more than common sense. You should have a strategic plan for that situations. Judges, what would you do? Would you let them into the field? Okay, so any other comment? Everyone agreed with Judges' remarks? Okay, so, but thing is, you have to plan in advance. So you have to announce using the PA announcement saying, if you want to rush into the playing field, you have to go that way, exit A or B, or you have to provide special location. Or some people who wants to leave the arena as early as possible. So let them know, okay, if you want to leave the arena as quickly as possible, then you have to go the other side. Designated location. Okay, go to exit number F or G or H. So they can make a decision, either stay or leave. And then if I want to stay the arena, then okay, I'm going to follow that direction. And then, or if I want to leave, then I have to go the other section. So you have to plan in advance. Okay. And number 3, October 22nd, 2005, a student from the University of Minnesota, Morris, died from injuries sustained after football players and fans accelerated by a double overtime homecoming win. So this big game, double overtime homecoming win, pulled down a goalpost. So two fans pulled down the goalpost. So they died. So likewise, November 23rd, 2002 was somewhat infamous as fans at the Ohio State University, Clemson University, North Carolina State University, University of California, Berkeley swarmed the playing field after football games on that day. So this is a rivalry game. So all the rivalry games will be broadcast on same day. So NCAA scheduling in that way. So every rivalry game will be on the certain day, especially on Saturday. Number 4, when OSU and the University of Miami played in 2003 Fiesta Bowl in Arizona, police OSU officials in Columbus, Ohio were prepared for post-game troubles. So after the game, depending on diverse scenarios. In addition to scheduling extra police and implementing an on-street parking ban for the neighborhoods bordering the OSU campus, Ohio Stadium was locked down and the goalposts were removed from that weekend. So do it quickly, or either before or after. But this should be planned wisely. Okay. So I just want to explain about the vicarious liability. So I just want to see vicarious liability first. Okay. So I'm going to cover vicarious liability in a fourth slide. So let's take a look at crowd control. So learning from Behrman versus Notre Dame case, I want you to practice constructive notice, or some people call it constructive knowledge. So actual knowledge and constructive knowledge are same as actual notice and constructive notice. Even though the wording is different, but I want you to understand the same meaning. So duty to keep facility reasonably safe for spectators, and then duty to exercise reasonable care to protect public from physical harm. So this is the definition, crowd control. So your duty of reasonable care will be different based on your status, invitee, licensee, and trespasser. So that's the number 1. And I want you to keep in mind prior similar instance rule. Prior similar instance rules. You can see this case, this notion in my article I just gave you. Something happened, especially some negligence occur, then the organization should do something to prevent from similar things happening from the same location. If there's a fight in the restroom at the baseball stadium, you have to take some action to prevent further fighting to occur in that same location, such as provide more number of security personnel, especially at the same location, or you can fix the lighting system, so make it lighter in the location, so people can see from a distance what's happening there. Okay, or you can provide some security camera like a CCTV, so their location can be monitored by the main office at the stadiums. So you have to do something. If you do not, then you will be liable and low possibility of winning the case. So the court will ascertain whether a certain incident was foreseeable by looking at what has occurred. What has occurred previously at the location that was sufficiently similar in character to make it foreseeable that another occurrence of that kind could happen? So can you think of any examples indicating prior similar instance rule? Yeah, the article I gave you. There's a fans at the baseball venue, baseball stadium, falling again and again. Why you didn't do anything? Okay. Same baseball stadium. Okay. It's unstoppable. We live in 2015. Okay. Why we used the rules and regulation was set in 1927, long time ago. This is almost 85 years old rules and regulations. We gotta do something differently to prevent from fan from falling at the stadiums. Anyone? Any other examples? Raise your gun to the players. Yeah. So if kind of interfere players using the razor pointer, then probably that should be protected. So razor pointer should be listed as one of the banned items toward the stadiums and arena. Okay. Okay. Okay, number 2, injuries due to alcohol consumptions. So tailgating and alcohol consumption tied to sporting event. So a lot of people believe sports is kind of entertainment, and some people call it sportainment. So combination of sports and entertainment, and which involves the alcoholic beverages most of times. But once again, money versus danger. Revenue versus liability, and then betterment can be considered as one of the unique lesson for sports managers. But I just want to show you one case. Recently, landmark judgment. So I just want to explain this case. I want you to remember, in the amount of $135 million was awarded against Aramark. Aramark is one of the top three concessionaires. They provide food and drinks at the four major baseball stadiums and arena throughout the world. Aramark doing their business in Korea too. So they provide food and drinks at the international schools in Korea, and then they're running some their own restaurants too. The liquor concessionaire at Giant Stadium, the jury included punitive damages of $75 million because they believe Aramark has sold beer who was visibly intoxicated. This patron, Daniel Lanzaro, left the stadium in his truck with a blood alcohol level 2.5 times the legal limit and collided with a family in a car. The child in the car, 2-year-old Antonia Verney, became quadriplegic. So what it means, think about, one of the fans was drunken, drank beer at the baseball game, and DUI, drinking under influence. He was driving drunk and collided with a family with a minivan, and then one of the little girl, right, 2-year-old Antonia Verney, became quadriplegic. So one baby is a permanent injury, disability, causes how much money? $135 million. Okay, I understand how serious this case has been handled. However, who were the defendant? Who paid them money? Aramark. Does it make sense to you? Aramark is a company providing food and drink. Aramark nothing to do with driving. And the victim's family, Antonia Verni's family, parent filed a claim against, not the driver. Aramark, the company who provided the alcoholic beverages to the stadium. Is it reasonable? So the court, yeah, Chris, any? Okay. Yeah. Okay, so as Chris mentioned, so this is a key one. So Aramark has sold beer who was visibly intoxicated. So there's a policy. You cannot sell beer to the person, to the patron who look intoxicated. And then they ignore the policy. This is kind of clear. So this is an example of vicarious liability. Vicarious liability. Aramark is a duty of care to train the employees. And then they fail to do it, like a duty of care, duty of education, duty of training the employees. And then breach of duty. Since you breach of duty, you didn't train your employees. Well, because of that, one of your employees sold beer who visibly intoxicated, and then that causes that accident, and there's huge damages. And then this may be criminal law, criminal court, and also civil court. So the victim's family, they were looking for financial compensations. So Aramark actually became the sole defendant for this case, and then the court decided that Aramark was to provide $135 million to the victim's family. Okay, so next one, injuries caused by players. Injury caused by players. Players leaving field of play, respondeat superior. So when I say respondeat superior, is same as vicarious liability. Respondeat superior typically applies. Vicarious liability by team may apply, but most of times vicarious liability may not apply to the situation where intentional tort or more than mere negligence occurs. Okay? If you're upset, if you commit any crime, I'm team manager, I'm your coach, I'm not responsible in terms of respondeat superior. I don't care what you do outside the game, outside the realm of the sports organization. You are dirt. I don't have any authority. Okay. So the scenario of players leaving the field to go into the spectator area is not confined to professional sports. So Arizona Interscholastic Association passed a sportsmanship rule in March 2005, providing 4 years suspension for any player who enters the spectator area. The player's team will also be put on probation if a violation occurs. But have you heard about hazing? Hazing, H-I-Z-I-N-G, hazing. Well, rookie hazing rookie. So especially, in a nicer way, baseball players, like rookie players. Kang Jong-un would have been done it if he was hurt, unless he was hurt. So wearing the uniform, I mean, very interesting uniform. So people can make fun of them kind of for fun. But the definition of hazing is a criminal law. So in military, so there's a hazings all the time. So if you have a new player, kind of younger, then yeah, we actually give a hard time. So that's the hazing. So it happens a lot in the United States. So especially in collegiate sports and in high school sports, they invite one of the new player or freshman players to the party, and then try to force them to drink a lot. Some other, I mean, different ways. Okay, it can be as violent as it can be. So if it's the case, most of times coaches understand, and coaches are aware of there's hazing or initiating kind of going on at a certain location. But if it's the case, then the coaches will be liable. Even though that's the criminal law, but coaches should have stopped them to doing. Make sense? So vicarious liability or respondeat superior, enjoying organization is held accountable, organization or your supervisor, for the actions of each employee so long as the acts are done within the scope of employment. Within the scope of employment. So that's the first requirement to successfully constitute vicarious liability. So within the scope of employment, so this is examples. So if a driver of a delivery truck owned by a sporting goods store drives negligently and injures a third party, the negligence of employee is imputed the employer under the principles of respondeat superior, so long as the accident occurred in the scope of employment. That is, while the employee was in the process of making deliveries for the employer. So if you hurt while you're working, by your contract says, then this should be said within the scope of employment. Please note that an employee's job description was as written in an employee handbook, or an employee contract is usually not synonymous within the concept of scope of employment. Job descriptions do not generally encompass all of the duties actually performed by employees. Often, the employment contract includes a rather nebulous phrase. Instead of listing all your duties and responsibility, they try to use nebulous words or terms to the effect that the employee is expected to do X, Y, Z and other duties as may be assigned. So they try to have some room for themselves to protect themselves. So for example, if a coach drives negligently while transporting players to an away match, that negligence will certainly be within the coach's scope of employment. That's the clear job or duties of coaches. Even if the duty of transporting players was not specifically delineated within the coach's contract. Even though your contract doesn't say driving or transporting your players to the away game, but it can be considered as your job and duties and job. Okay? So, what else? Within the scope of employment, can you think of other examples? So baseball players, I mean actually basketball players practicing and spraining their ankles, that's the assumption risk also, that's the within the scope of their employment. The baseball players were getting salaries by playing basketball. What about they were injured while going to away games? Yeah, yeah. Away games, I mean especially taking a flight or bus trip to Changwon LG, right? LG Sakers, and their road trip all the time. So if any accident occur during their road trip for the next game, probably we can say that's within the scope of employment. Huh? Mia? What do you mean? Yeah. Yeah, yeah. So I mean, as long as even though you know playing away game cannot be listed in your jobs and duty. I mean, responsibilities, right? It's not a contract. Contract doesn't say you have to travel to certain location on certain day, because so many things to list if it's the case. So they say you will play away games as assigned or as scheduled assigned, right? So as long as you were hurt, you were injured while you're doing your job, then we can say that's within the scope of employment. But yeah. Mm-hmm. Yeah. Oh, absolutely. I mean, the airline has an insurance policy, and then from this purpose, that can be considered as within the scope of employment. So usually, I mean, some sticky situation can happen. In the news, we can hear quite often, employee kind of died after drinking at midnight with a client. So after their work hours, right, 9 to 6, 8 to 5, whatever, but in midnight, 11 p.m., okay, they're meeting their client. So this is kind of extension of their work, right? So some courts say, oh, that's within the scope of employment, because meeting the client is a part of the job. Or some people say, okay, so that's more than their duties. So depending on what the jury, especially judge, define within the scope of employment, the decision will be totally different. Some fans actually filed a claim in Korea. They were hurt by playing golf on Sunday, but who did they play? Client. So Sunday, the weekend, he was not supposed to be working. And then he was asked to play golf because that's part of his job. So he was hurt. So he filed a claim based on the notion of within the scope of employment. I hurt because I'm doing my job. So company should pay for me, right? Okay. So that notion can be applied to several similar situations. Okay. So there's three major respondeat superior or vicarious liability. The first, negligent hiring. Negligent hiring. If you hire some what can I say, unqualified employee, then or you miss the protocol of hiring process, then your supervisor will also be liable by the notion of vicarious liability. Such as if I apply for the professor, then you have to organize ad hoc committee, search committee. So a couple of professors and some couple more people. It may cause like 2 days. You have to present, you have to meet all different kind of people, you have to stay in a hotel. So a very long process. But if university fail to check their background, did he or did she commit any crime before? So when I was invited by Hanyang University, I was asked to provide my background check. It should be provided from FBI because I work in the United States. So I actually contact FBI and then have to provide my proof of being innocent, no criminal record to the university. And also this is a requirement for the Korean Education Department. So anyone who work outside Korean university, then they have to provide some criminal record. So if university failed to do it, then that's the negligence hiring. And then if it's the case, and then negligent will be follow the chain of command all the way to university. So this is an example. You are the chief administrator for local youth softball league, in charge of hiring coaches. It happens a lot. For the upcoming season, the coaches are not well paid, and it is difficult to get enough coaches for your 8 teams. The participants in the program are young girls, ages 8 to 14. Gotta be careful. This minor female teams. The season is fast approaching, and you need to fill the last coaching position very quickly. Finally, a man applies who had just moved to your area. He seems very personable, and he tells you that he has coached softball for the last 10 years in other youth organizations. You are very impressed with the person's knowledge of the sport and his outgoing personality. So you hire him, doing no reference checks whatsoever. No reference check, that's clear. If he had done any investigation, you would have found out his last coaching position ended with accusations against him of sexual abuse of his female players. And also, if you had done a criminal background check, you would have uncovered a conviction for sexual offense with a minor. 1 month after being hired, this coach sexually molested a girl on his team. So what liability can exist? So once again, he committed sexual offense. This is a criminal law. So based on the notion, your organization or supervisor would not be negligent. However, you will be negligent not by his sexual offense, but your negligent hiring. You didn't do your background check, which is one of your duties. Okay, you breach of duty, right? So can you understand 2 different things? When you hire, you have a duty to checking the background of an applicant. You didn't do it. So that's why you have a vicarious liability. But for his criminal behavior, you won't be negligent. For example, if you did criminal check, you have a duty and then you did not breach of duty. However, he committed some sexual offense, then you won't be negligent in terms of vicarious liability. No organization will be liable in terms of vicarious liable for criminal behavior. So second, the second is negligent supervision. So once again, there's 3 types of vicarious liability. The first one, negligent hiring, and second, negligent supervision. You are employed at a tennis club as the head teaching pro. According to your job description, you are responsible for making sure that the assistant pros run instructional drills properly. Since you are very busy with your own lessons, you have not watched any of the drill lessons run by Freddie forehand. If you did observe any of the drill lessons, you'd see the forehand is not following good safety practices as he sets up the overhead drills. He's having students hit overhead while the people on the other side of the net are doing another drill. Someone is hit by an overhead and seriously injured. So what liability can exist? Negligent supervision. So that's why this is in terms of hierarchical organizational structures. So employee from the interns, assistant manager, right? Intermediate managers and supervisor. So whatever hierarchical organizational structure you have, then you need to do your job correctly. As a supervisor, your job is to supervise your subordinate in a good way. If not, there's something going on with your subordinate, with a client, then you might be liable in terms of negligent supervision. Okay. Yeah. Uh-huh. Yeah. So if you did your criminal background check, and then he or she was clean at the time, and then you are not negligent hiring. Yeah. Because there's no reason you will be negligent, because you have a duty and you conducted your duty, you completed your duty, and then your subordinate actually committed sexual offense. We cannot prevent anybody from causing criminal behaviors. No, not at all. Yeah. As long as you did your job. Yeah. Okay, there is an answer, probably answer after the story, so I want to read it. Just make sure you understand the concept. So that's why I provide all the answers after the fact. So page number 60 and going to 62. So the last one in terms of vicarious liability. Negligent retention. What does that mean, negligent retention? From what you know. If you find one of your subordinate doing negligent, you have to take some actions. So warning sign, or personal interview, or some suspension, or salary cut, or worst case, fire. So that's your job. You have to play by rule. Okay, Bob Strong. There's so many people will show up in this case. Bob Strong is a general manager of Fit and Well, a health and fitness club that is owned by Wynn Corporation. Strong is in charge of all employment-related matters, including hiring, firing, and disciplining employees. 6 months ago, Strong hired Adam Easton to be club's director of fitness. Easton came highly recommended with super credentials. After 1 week, that Easton had screamed at her for making a scheduling mistake and had essentially backed her into a corner as he screamed, using his size and strength to intimidate her. Strong listened to Riley's story but did not investigate further and did not talk to Easton about this incident. Once again, if you identify and recognize some of the issues, you have to take some actions. If you fail to do it, then less chance to win over this case. Similar example, like a stalking. If somebody trying to follow you all the time, but you have to give signals at least 3 times. if you believe somebody following you or harassing you, when you didn't respond to that person, what you think and what you say, what you're supposed to say, then less chance of winning that stalking case. So you have to express what you feel, such as don't do it, don't follow, at least 3 times. That is a strong indication that you don't like that behavior, you don't like that actions. Same thing. If you recognize some subordinate negligent behavior, you have to do it. If you do not, then your subordinate believe it's okay to do it. So after 1 month on the job, Strong received another complaint about Easton's violent behavior from Jessica Barker, another club employee. On this occasion, Easton screamed obscenities at Barker and grabbed her arm to emphasize a point. Strong again listened to Barker's report, but chose to do nothing, since Easton was doing a great job outside this outburst. Over the course of next 5 months, Strong received similar complaint from 5 other employees and 1 club patron about Easton's increasingly violent behavior. Strong once had a chat with Easton about this issue, but he never took any disciplinary actions. Okay, no reason. You have to answer why. Why you didn't take any disciplinary action. If you fail to answer it, then you will be negligent. Retention. In the 6th month, Easton exploded and punched one of the club's patrons, sending her to the hospital with a broken jaw and a concussion. This patron is now going to sue based on Easton's intentional tort. Battery. Once again, assault and battery, intentional tort, you won't be liable. You're liable only because you didn't take any disciplinary action, which is negligent retention. If I'm the plaintiff, I would be mad because I reported and then the supervisor was aware of his outburst, his emotional immaturity, right? And then you didn't do anything. You didn't take any disciplinary action. So that's why you should be liable based on the notion of negligent retention. You should be prevented if you took any disciplinary action before and properly. Yeah, but yeah, probably the jury and or judge will make a determination if it's a necessary or it's a a reasonable or logical process. But in this case, obviously he didn't do anything effectively. Yeah. So probably you and then your supervisor and probably owner of this fitness club will be liable in terms of negligent retention, because I have to report to my supervisor. My supervisor is supposed to report to the owner of this fitness club. If I fail to do it, and then whose job is that? My supervisor probably should ask me if anything wrong with the employee. So through the chain of command, and then one person failed to do it, then probably negligent retention will be or might be applied. Okay, so we covered negligent hiring, negligent supervision, and negligent retention. So I want you to understand. But this respondeat superior or vicarious liability will not be applied for more than mere negligence. Make sense? Criminal law, criminal behavior, nobody responsible, because there's no way to prevent criminal law from one of your employees. So injuries caused by projectors. Injuries caused by projectors. Once again, limited duty rules is explained in my article in Korean. So limited duty rule, facility owner. So because of this limited duty rule, there's no way to protect people from falling from the baseball stadium. And then they are hit by foul ball. Foul ball runs very fast. 160 miles an hour, more faster. So even though you watch the game, and then there's no time to avoid the foul ball. Yeah, that's right. Assumption risk is uses by baseball teams and facility owners. But this is a very tricky and then kind of gray area. It's no, actually, we agree that the facility owner or stadium owner and franchise owner should install safety net thoroughly, more thorough way to protect more number of people. But because the United States actually adopts common law, which is a collection of case law, there's no way a fan who hit by foul ball will win over the franchises. In the court, franchise owners, stadium owners overly abuses the notion of limited duty rules. Okay, baseball team, especially baseball and ice hockey is two major sports who uses by limited duty rules. Football. Okay, if you hit by football, you don't hurt, right? Baseball and ice hockey park. So you can see a lot of hockey players don't have front tee because they hit by hockey puck. There's no way to protect. So baseball fans, same thing. Every game, 3 fans out of 2 games hit by a foul ball. And some of them, fatal and then some are minor injuries. But it's not liable for injuries to spectators that result from projectors leaving the field during play. And assumption risk, that's the first one, like Chejin mentioned. And secondly, limited duty rule. The owners of baseball stadium cannot install the safety net throughout the stadium. And also, some fans complain if there's a net and then I have to watch the game through the net, I feel safe. However, that decreased the enjoyment of the watching the game. So kind of 2 split opinions about installing safety net. But obviously, extension of safety net is necessary. My humble opinion. So I just want to show you the cases. So this is it. Okay, so this has been solved in 2013. The plaintiff had been a season ticket holder at this minor league baseball, professional baseball franchise for over 20 years. His tickets were in the Viper section. Viper is one of the sponsor section, which was protected by netting. Sometime during the game on August 13, 2008, the plaintiff and his family went to the executive club, the only area in the stadium not covered by vertical netting. While conversing with someone there, the plaintiff stopped paying attention to the game. As he heard crowd noise, the plaintiff turned and was hit in the eye by a foul ball. As a result, the plaintiff lost his eye. This is a real case, based on real case. The plaintiff brought an action against the baseball club alleging negligence. The negligent baseball club moved for summary judgment, alleging that the baseball rule, limited duty rule, should be adopted by the court. Since the club complied with this rule, summary judgment for the baseball club should be granted. The trial court did not adopt the limited duty rule and denied summary judgment. The defendant was given permission to appeal this issue to the Idaho Supreme Court. So Idaho Supreme Court affirmed the trial court's order. So the court reviewed the case law from various jurisdictions, acknowledging that some version of the limited duty was the majority position. However, the court noted that it did not believe there was any public policy reason to adopt limited duty rule in this jurisdiction. The court stated that the defendant did not show any statistical evidence that there was a high prevalence of the foul ball injuries to the spectator, nor did the defendant address any sign issues to prevent occurrence of foul ball injuries. Furthermore, the court stated that without this information, drawing lines as to where a stadium owner's duty begins, where netting should be placed, and so on becomes guesswork. The court then concluded that if the baseball rule, limited duty rule, as also called baseball rule, same thing, to be adopted in Idaho, it should be legislature's prerogative to do so. The court therefore declined to adopt baseball rule in Idaho. So this is one of the few cases. Most of the times, the owners of baseball team and stadiums enjoyed limited duty rule and assumption risk. Back up your baseball ticket. What do you say? Okay, you have to assume all the potential danger within inherent the stadiums. The risk inherent at the game of baseball stadium. You have to watch the game. Hit by foul ball, that's the kind of nature of the sport. It's a spectator sport. What do you expect? Same thing, sprain your ankle while playing basketball. And then moreover, limited duty rule was adopted by some state saying there's no way the owners should install safety net. But Idaho State kind of an unusual anomaly in this category of the lawsuit. Any questions? Okay, I have a couple more slides. So limited duty rule, and then other spectator injuries. Sutton versus Eastern New York Youth Soccer Club. So I want to read it, but doctrine of assumption risk applies not only participants but also to spectators. Doctrine of assumption risk. Same thing, baseball club. Okay, you have to assume. Okay, once again, hit by foul ball at the baseball, hit by hockey puck at the ice hockey game, same as playing breaking your fingers while playing volleyball. Okay, so your responsibilities as a future sports managers, spectator injury, develop crowd control based on specific event factors. You have to create crowd control manual or policy which should fit into your specifics of your nature of the event. Baseball game should be different than baseball game. Basketball, baseball, hockey, depending on the location and venue the game played, then you have to develop very unique and event-specific or sport-specific crowd control policies and manuals. Secondly, develop alcohol management policies and enforce them consistently and fairly. Alcoholic beverages. So I think this might be a huge issue in the next 5 to 10 years in Korea. Okay. Selling alcoholic beverages, especially baseball stadiums, we don't see many major legal issues, but based on my humble opinion, it will be one of the major one we can see in the future. Yeah, that's true. So they have to come up with very specific and clear policy in terms of alcoholic consumption at the baseball stadiums. Okay, so one more. Make sure mascots do not distract patrons from field of play. So distraction, this is one of the exceptions. If mascot distract one of the fans at the game, and the fan was hit by a foul ball or any projectors leaving the field of play, then the mascot will be liable. So mascot should be warned that do not distract any fans during the game. The last one, ensure spectators are protected while in a concession areas. Also, especially minor league baseball. So you have to wait in line to get hot dogs or drink. And then there's no protection net. There's no safety net, especially minor league baseball game. So you have to do something. You have to take some action to protect fans waiting line at the concession area. But it doesn't apply to Korean situations. We are kind of far away or downstairs at the baseball stadium, so we don't have any possibility of being hit by foul ball. Okay, so any questions? Okay, so next week we have a second quiz, and you have a assignment of Bearman versus Notre Dame cases. And by tomorrow, by 5 o'clock, you have to submit your assignment, Nabojini versus Nabojini case and Mekichan case, 2 cases, 9 questions and 6 questions respectively. And then one more thing, if you look at the schedule, we have midterm has been scheduled on 14th of October. 14th of October, but I propose we can have exam on 28th of October instead of 14th.